Okay, this will be our final segment in this chapter, and we're going to cover major U.S. employment legislation. And the reason why we're going to cover this is that it has implications for how IO psychologists do their work, because they have to take these findings and these rulings to heart and make sure that they aren't encouraging an employer to use selection practices that could be discriminatory. All right, so if we look at the timeline of how of the laws that have come into place over the past, well, we're pushing 50 years, right? 1963 was the Equal Pay Act, 1964 the Civil Rights Act. Then we had some amendments. The executive order in 1965, we'll talk about age discrimination in 1967. Americans with Disabilities came along in 1990, and then some amendments to the Civil Rights Act in 91, and then the Family and Medical Leave Act came in 93. We've had a couple of new things recently, but they're just sort of like tweaks on existing legislation, so I didn't bother, populating this line with too much. The Equal Pay Act made it illegal to provide unequal pay and benefits based on sex to people who are holding equal jobs. So it's kind of interesting that this is something we still talk about like it's new, but this is something that like we need to get equal pay. But since 1963, it's been illegal to pay people different amounts based on sex. If you're going to pay people differently, you have to be able to make the argument that there's a sizable and reasonable difference in the work that they're doing. So the employer has to quantify why two employees are making a different amount of money for the same, for holding equal jobs. If the employer wants to make that case, it's a good reason to have a job analysis so that you can quantify and delineate exactly what makes these jobs different. The Civil Rights Act prohibits employment discrimination based on race, color, religion, sex, or national origin. So that's been the classic list of groups that you cannot discriminate against, that you can't say, well, I'm not going to hire Jews. I don't want to hire women. I don't want to hire people with dark skin or something like that. Can't say, well, no Irish need apply, which was a common sign in the early 1900s. Can't do that anymore, thanks to the 1964 Civil Rights Act. One aspect of the Civil Rights Act is that they designed the EEOC to enforce these rules and to oversee employers and to field complaints about employers who employees think might be violating these rules. Now, in 1965, there was an extension to the Civil Rights Act where these rules were going to apply to federal employers and to their subcontractors and stuff, so that initially there was a little bit of a loophole. If you worked for the government, it was sort of okay, which I have to laugh because kind of interesting that you'd make a law and then your groups don't have to follow it. But so 1 year later, they're like, I think we need to apply this to all jobs, including, the federal government employs a lot of people, and there are a lot of contracts and subcontractors that work for the federal government. Now I'm skipping ahead. I'm sticking with the Civil Rights Act here because in 1991 they updated the Civil Rights Act, and what they did in 1991 was basically reaffirmed and strengthened it, and especially emphasized sexual harassment as a civil right, so that women should not be objectified and stuff like that on the job. So let's talk about the Civil Rights Act for a second. We'll come back to our timeline in a second. In 1971, Griggs sued Duke Power, which is in North Carolina. He wasn't hired for the job that he applied to, and he presented adverse impact data that showed that there weren't very many African Americans working for the power company. And Duke Power said, well, those numbers were unintentional. We weren't doing it on purpose. But they were found to have been discriminatory because their selection battery was not really directly job related. So when they were saying that they were unintentionally ending up with more whites than blacks, that it was not on purpose, it was, the selection battery was determining who they were hiring. And the court said, well, but your job, the selection battery doesn't really seem to have that much to do with the job. So get a better selection battery and stop discriminating, right? So that was one of the seminal cases where the Civil Rights Act was being implemented, and that's you can kind of see in this description that the plaintiff, who was the employee, the candidate who wasn't hired, had to provide adverse impact, and then it was up to Duke Power to defend itself, and they weren't able to do a very good job of it. So they lost that case. Let's see what else I want to tell you guys about. Oops. Now, the Civil Rights Act distinguished between what's called disparate impact, which is when you have unintentional discrimination. This is where most personnel law cases are, where they're like, well, we didn't mean to treat a group unfairly. Disparate treatment is when it's intentional, and it's because of differential treatment. It's resulting from differential treatment. So disparate impact is where the groups are having different impacts from each other, and the company, the employer didn't necessarily intend to do it, but that's the effect. In disparate treatment, there is an intentionality to it where you are treating the employees differently, and therefore they're getting paid less, or they're not advancing, or they're not getting hired, or they're more likely to get laid off, or like that. The bona fide occupational qualification rule says that the employer must show that your sex, your religion, your national origin is really required or necessary for the job if they're going to use it as a way to discriminate. That it really matters whether you're male or female in order to do this job correctly. I think it would be, if let's say a woman wanted to try out for the NFL, and the NFL said no women may apply. And so the woman took the NFL to court and said, I wanted to try out, and they said I couldn't because I'm female. I think that it wouldn't be really super hard for the NFL to make the case that gender is a bona fide occupational qualification for most of the positions on the team. I think the one exception that they've been toying with is kicker. But I think that you could probably make a pretty good case that the things that go along with being male go along with playing in the NFL. Not that you have to be male, but that you have to be a person who possesses these things, and mostly males possess these things. So, I don't think you could sue the Catholic Church for only hiring Catholics to be priests, right? These are sort of, some jobs require certain characteristics. And it's not discrimination when you're hiring people who have those characteristics. Showgirls are pretty much all girls, right? There are certain jobs that you have to have certain characteristics in order to be able to do the job. Other jobs, it's hard to make that case. I'm thinking of a few off the top of my head, but it's really, most jobs are the sex or the race or the religion, your national origin, are pretty arbitrary. It really doesn't matter, right? And that's the thing about disparate treatment. If you have been discriminating on purpose, you better be able to make a case that it's because the job requires it. You better have quantifiable evidence that the job requires it. Now, the Civil Rights Act, like I mentioned, in 1991, really strengthened the sexual harassment law. And so I thought I'd mention a couple of things about it. Now, I'm from the West Coast, so I call it harassment, but apparently other people call it harassment. There's quid pro quo harassment, where really your advancement or your continuation in the job is explicitly contingent on you performing sexual favors. And this actually is the least common sexual harassment case. I've got this cartoon where we've got formerly the cute blonde in the mailroom, like she advanced because of quid pro quo sort of situations. Quid pro quo means I'll do something for you and you'll do something for me, right? This isn't the most common type of sexual harassment, though, because it takes a lot of nerve to actually make the clear-cut quid pro quo kind of proposition. And especially, we've had a good solid 20 years of very strong sexual harassment law. So you don't see that kind very often. Instead, it's more the hostile work environment type that's more likely to be the focus of a lawsuit these days. We have the woman saying, just because I wear wings and have a glow about me, don't call me Angel. Those kinds of pet names are considered a hostile work environment. Telling off-color jokes in front of in mixed company is considered a hostile work environment. Hanging up pictures that are offensive to other people in the group is considered sexual harassment because it's a hostile work environment, because every day you have to walk past your colleague's desk that has these offensive pictures on it. The thing on sexual harassment is that the job of the employee who feels harassed is to they have to report it and give the employer an opportunity to rectify the situation. So you can't immediately go from I feel uncomfortable here to filing a lawsuit. You have to go from I feel uncomfortable to reporting it to somebody who could make it stop. And then when nothing changes, then you are in a position where you can file a lawsuit about it. And then once the lawsuit is filed, it really becomes the employer's responsibility to defend themselves from the lawsuit. It's not really, once it's at the lawsuit stage, it's really not the plaintiff, the complainant's job to make a clear case. It's the defendant's job to show we stopped it, or we had policies in place and we did everything we're supposed to do. And that's why a lot of you have been through sexual harassment training and things like that, so that employers can say, well, all of our employees were trained and nobody made a complaint to us. And